Hi, everyone. Welcome to this week's weekly live immigration attorney chat here at Immigration for Couples. I'm attorney Megan Pastrana, and my firm, Immigration for Couples, is dedicated exclusively to helping couples across the nation and across the world in navigating the U.S. immigration process. And I see we have a lot of people joining us live, and you know the drill. I always like to ask, how are you doing first and foremost, especially if you're going through an immigration journey? How are you doing? And where are you at in the world? And where are you at in your immigration journey? I always like to start with those questions. So some of those of you who join on a regular basis know that and have already started putting that in the comments. All right. And it's great to be with all of you. Typically, I host these live events on Tuesdays at 11 a.m. Eastern time. And we just had a change of schedule or some scheduling conflicts. And so I still wanted to meet with you all. And we moved it to Friday. So I'm so glad you were able to still join us. For those of you who are watching on the replay, please do a hashtag replay and answer those same questions. Let me know, how are you doing? Where are you at in your immigration journey? And also, where are you at in the world? And if you have any questions, please feel free to ask those too. Do the hashtag replay and let me know what your questions are, because I do read the comments and I do like to go through the questions, because I know if you have that question, likely others do too. And that gives me information on what video topics you all would like to hear. And then last but not least, I did want to let all of you know about our free resource center on our website, immigrationforcouples.com. And I can actually post that in the comments too here for everyone. Let's see, there it goes. I posted that in the comments, and the free resource center is something that my team and I created with a lot of love, care, and consideration for all of you. And one of the main pieces in that resource center is a free webinar. In that webinar, I really talk about the different options that are available to couples, how to understand which option is best for you, how to prove your relationship, and really next steps on your journey, and how to not just survive, but thrive in that process. And I know we have a lot of questions coming in, so that is what I will go ahead and transition over here to as well. I just want to check and make sure I'm streaming on Facebook, LinkedIn, Instagram, YouTube. Yep. Green light on all 4 platforms. So if you have questions, please throw them in the comments. I ask that you just ask your question one time. I will get to them in the order that I receive them on my end, and I will do my best to get through all of the questions in the time we have here today. And I also ask that you just ask one question out of fairness to everyone. And let me see who is first in the queue. I'm not sure. It seems like, there we go. Terry. All right. You're the first in the queue. So you said your husband has an interview in Morocco on April 8th. That's great. Congratulations. And you just filed the visa in December. Oh, perfect. That's so nice of you. Yes, that you had filed and you're, getting to this interview stage and you're wanting to kind of give some encouragement to everyone. Yes, and that is a shorter wait than what is typically expected. And I think you mean that you did everything on the National Visa Center and then got the interview, right? You didn't go from filing an I-130 petition to having an interview, just to kind of clarify. Okay, and then you have your question. It's like a 2-part. So thank you for that encouragement for everyone. In that notice, it says that you should bring all of the original documents filed. Yep. And that's correct. There is a lot of documents when we give our clients their packets to take to the interview. The packets are very large, usually a couple hundred pages, plus taking all of the originals as well. And so if I can tell you what you need to take. So I'm not going to be able to give you like a conclusive, you need to take all of these things, because every case is a little different, but that's good that you received that, that notice of the interview and that it has those instructions in there. You need to definitely follow that interview notice, and you should also check the prepare for your interview on the National Visa Center website. They have they'll have the list that they email you, and then they have that list online, and you should really compare both, because I will tell you that from practicing immigration for many, many years, we always find that the list that they email and then the list that they have online, that sometimes there are different documents. And so you want to make sure you have everything. But those are the 2 lists that I would check. And then making sure, for your particular case, I know you mentioned, like, see, for your case, you have a joint sponsor. So yes, you would want to make sure you take that joint sponsor paperwork and financials and updated financials, since we're here in a new tax year, if you didn't have the 2024 taxes when you filed. And then also going through and making sure, you have the police background checks and that you have updated relationship evidence and really everything that's on the list. It is quite a bit that you will have to take to the interview, but definitely check that, double check your email, double check the National Visa Center website. And that's a good place to make sure, that you have everything on those lists. But congratulations on the interview. That's really exciting news. And that gives hope, I hope, to all of you who are, just starting out or in the middle of your journey. I love when we have celebrations or success stories in this community, because it really does help you to see a light at the end of the tunnel. So, all righty. Okay, so Betty Ann, you're asking if there are any updates, or rather, has the process really slowed down, or is it kind of on track? And I think you're asking, have we seen like a slowdown in applications? So for the spouse visa in particular, we have seen a gradual yet dramatic slowdown on the spouse visa cases, and since last year. When I was meeting with individuals last year about this time, but in the spring, summer of last year, I was saying, hey, we're really seeing I-130 petitions taking about a year at that time. And understanding for all of you that immigration wait times are fluid. They are always changing. Immigration provides an estimate on their website, and that estimate is typically for about 80% of the cases. So understand, you could get a decision sooner or it could take longer. And that those estimates, like I said, they're always changing. And if you have an online USCIS account, you'll notice that you'll be feeling like you're riding a roller coaster as well. They will do, it's going to take, 8 months, for example, and then you'll see it count down, and you'll see it kind of go up and down in the portal. And then sometimes it'll say taking longer than expected. And immigration, they try to give estimates, but they are not always the most helpful. And to answer your question, though, we have seen the wait times go up for the I-130 from that 12 months that I was estimating last year. We're really seeing that petition phase taking about 16 and a half months right now. So if you check the USCIS website, you'll see that it's about 16 and a half months. And then for the fiancé visa, last year we saw it take a dramatic dip in terms of the wait times, in a good way, that it was taking less time. We had some fiancé visa petitions that were approved in a matter of a month or a few months, and then it kind of went back up to 8 months. Fiancé visas were created to be faster than the spouse visas, knowing that you have this extra step when you enter the US. And so historically, the fiancé visa has always been meant to be faster than the spouse visa. So that's common. That's what we see. But the spouse visa wait times are really at an all-time high in terms of that wait time. And this is just for the petition phase, the very first step in that process. But we are seeing about 16 and a half months. And I want to make sure all of you know that it's really important to let your voice be heard. Reach out to your congressional representatives and your senators. Let them know how these wait times are impacting you. Also, if you have an immigration attorney looking at filing an expedite request, we've done that in some cases. It really depends. You want to make sure that you have the criteria that meets immigration's expedite criteria, like an urgent humanitarian reason or a health reason. But there are some things that can be done to push the case along in some cases. But unfortunately, right now, the wait time for that I-130 is pretty long. And we've had a lot of individuals who've come over the past few weeks letting us know they've still been waiting, and they ended up getting a decision around the 15, 16-month mark. So answering more than what you're asking, but I know everybody's wondering, and I wanted to give all of those updates. All righty. Let me just check on my folks here on Instagram. Yours are the only comments that don't come through on my side. Okay. Yeah, and someone on Instagram is asking about I-130s too. This individual has said that they filed their I-130 about a year ago, and they're wanting to know how much more time to wait. So good. That kind of goes along with the question that I just answered, that we are seeing about 16 and a half months for that petition phase. We could see that go up more, we could see it go down, but that's where they're sitting at right now. And this individual's also saying and asking, hey, we are a same-sex couple. Are there going to be any problems with our application? No, immigration is legally required to treat your union the same way as any love and review it in the same way. So there is not a problem being a same-sex couple going through this process. Oh, great. Oh, that's very sweet. Someone on Instagram is also saying, thank you for all the videos you make every week. They've been very helpful. My fiance is on his way to the US. You've been a blessing. You're very welcome. I love having this. You're very welcome. Um, I love having this community. So all of you know, you can kind of look around and see everybody who's joining us here today. And just knowing you're not alone is really, really powerful. And knowing that there are others who are getting through the process. There's so much fear out there in the media and in the world right now. And it's easy that if you watch even like 5 minutes of the news to feel like, oh my gosh, are we ever going to get through this? Is this process still going to exist? And there's just so many fear factors out there. And so I think it's very important to have a community like this. So all of you know, cases are still being processed. Yes, the wait times are not great. The process can be stressful, but you're not alone. You're in community here, and we can get to the finish line together. All right. So my next question here in the queue. If the petitioner owes to the IRS but has an arrangement, so like a payment plan, does that affect the beneficiary at the consulate? After deducting the amount owed, the petitioner is still way above the poverty guideline. Okay. So when you have, they're not overdue because you have taxes owed, but you are on a payment plan, an installment agreement, so they're not overdue. So typically that wouldn't have a direct impact on the interview unless you don't make enough. And so it sounds like you've done that research and you've confirmed that for yourself. So what immigration is going to be concerned about when you're going through the green card process, you as the petitioner, be it a U.S. citizen or lawful permanent resident, they want to see you make enough for your household size. And then they want to see you're currently employed and that they want to see your income. So as long as you have that income, that's good that you're on that payment arrangement, then typically that's okay. So hopefully that helps answer your question. Goodness. Every once in a while, I get a tickle in my throat from allergies, and that seems to be the day that I'm having right now. So good morning to you as well. You applied for a joint bank account before your husband received the green card. The bank teller said that you signed attesting to be a U.S. citizen. We withdrew our application immediately after she told us this, but still had gone through the system enough to generate a refusal letter. Will this be a problem with his N-400? Okay, so for those of you who may have never heard of a false claim to citizenship, this is what this question is about. So when you are a green card holder, you cannot hold yourself out to be a U.S. citizen when you are not. So as a green card holder, it's really important when you work, when you get a driver's license, anything like that, that you are presenting yourself as a lawful permanent resident, as a green card holder, and not as a U.S. citizen. Because if an individual claims to be a U.S. citizen when he or she is not, that is a permanent bar. And so if that's something that an individual does even before receiving a green card, it can make you permanently ineligible for, and permanent, just like the word sounds, you would not ever be eligible for a green card. Of course, immigration always has exceptions within the exceptions, but in general, you aren't ever eligible for that green card. If it happens after the green card, then it can make you permanently ineligible to ever become a U.S. citizen. So situations like this that you are asking about, it's really going to be very fact specific. And I cannot answer this question in the context of this live session without understanding your immigration history, without seeing this document, without doing a legal analysis. So before you file the naturalization form, you need to speak with an immigration attorney. and make sure that you understand whether or not this falls in the camp of a false claim to citizenship, and then what are the impacts, because the advice could be you aren't eligible to file for US citizenship and you shouldn't file the form because you're putting your green card at risk. You're putting yourself in front of immigration with a violation, right? So I can't, I just gave you some, very important general information, but in terms of your question, that really requires some research and a legal analysis. And I really encourage you, do not file anything with immigration until you have spoken with an immigration attorney and had that research completed to understand, are you eligible? And if you're not, what are the impacts to your immigration status? All right. All right. All right. So, Joan, and hello to you as well. You're in the Philippines. Your husband submitted the I-130 form last December, and the passport you sent was your name when you were single. So, unmarried, right? Well, yeah, your maiden name. That's the word I was looking for. And will it be a conflict if I decide to change my surname in my passport, considering the one we submitted already still has your maiden name? And by the way, your husband is the petitioner. Thank you in advance. You're very welcome. So when you're going through an immigration process based on marriage, when you get married, the marriage certificate, the United States considers your marriage certificate to be a legal name change document. So when you're going through that spouse visa process, like this I-130 process, there are opportunities for you to update your name. And so if you've changed your name while this I-130 petition is pending, then when you get to the National Visa Center stage, you'll have an opportunity to record your name as it's reflected in your passport. So if you went ahead and you took your husband's name, you updated your passport, and you're wanting to take your husband's name for your last name, then yes, so there's going to be opportunities for you in the next steps for you to be able to update your name. So it would not be a problem. We have clients do that all the time, deciding whether or not they want to take their spouse's name. And if they do, then we just put it on the form the way they want. And the last name is the name that you can change with the marriage certificate. So you could either do a hyphenated last name or just take that last name. But yes, the short answer is there are going to be opportunities or with the future steps to be able to record your new legal name. Okay. All right. I like your name or your title of trying to figure it out. That is fun. Is the K2 automatically approved when the K1 is approved? If we are waiting on documents to present for the K2, should we wait to complete the K1 until all the documents are ready for the K2? So it depends on where you're at in the process. If you're at the petition phase, or if you are at the interview phase. But when you go to the consular interview, that consular interview is going to be for all applicants, the fiance and the children. So the K1 and the K2, and they should be adjudicated, which means they should be decided at the same time. So before that interview is scheduled, you do want to ensure that you have documentation for both the K1 and K2. So when you go to the interview, they have everything and they can make a decision on the cases all at the same time. All right. All right. Okay. Check on my folks on Instagram, since those questions don't seem to come through for me on this side. All right. And how is this helpful to everyone? Since I can't see you, I can't see heads nodding or anything like that. If you give me a thumbs up or a heart or anything like that to know that this is helpful for all of you, that would be appreciated. All right. So Joan, you have a second question. I typically only will answer one of everybody's questions out of fairness, but I know that a lot of people have this question. So I will go ahead and answer. You've seen in some Facebook groups that you can also try filing for the K3 even when we filed for the I-130 already. Will that make the approval process go faster? So the K3 is a vehicle or an option that we used to use, but K3s were created. So they were created in an attempt to give spouses an opportunity for a faster track like fiancés. But the reality is that the K3s take just as long, but typically longer than the I-130s. So it's, you can file them. Sometimes clients ask us to, we do, but you have to understand too that if for some reason your K3 would be approved, that puts you in a whole different process instead of set of steps that you want to make sure you're aware of before doing that. But for the most part, K3s are not approved. They take longer. So, there's no fee, but it's not really going to be of any benefit. And it does not make the approval faster. I know a lot of rumors are out there saying that that's the truth, but it's not actually. The spouse visa, it's taking 16 and a half months. Even if you file the K3, you'll find that it takes the same amount of time. Unfortunately, I wish the K3 worked the way that it was created to. One of those things, in immigration that's nonsensical. One of the many, many things. And good morning. You're in Ghana and you're getting ready to start your journey. Well, that's great. You're in a good place. We're really happy to have you here in our community. Okay, so Damien, see, it sounds like you have your application filed. You received your receipt notice, and then will this have the biometrics in the letter? Okay, so yeah, you'll receive a receipt notice after you file your application. And then in some case types, after that, you will have a biometrics appointment, which is an appointment where they take your photo and fingerprints. So that would come separately than the receipt notice. But that's great that you have your application filed. I know you've been working on that for a while. All right. So, can you apply for adjustment of status for your wife? She's currently in the United States if you're a green card holder through asylum. So, adjustment of status if you are a green card holder petitioner, that's typically not a possibility due to some of the complexities with immigration laws and rules. And being a US citizen puts you in a better position to be able to petition for adjustment of status. So I can't say conclusively yes or no without knowing all of her immigration history and her time in the US and the type of visa that she used to enter, etc. So there are still options for you to petition for your spouse. Absolutely. It just might not be adjustment of status. So I'd be happy to speak with you in private. And this goes for everyone. If you want to schedule a consultation, you can do that here at the bottom, 317-247-5040. You can call the office and my team will get you scheduled. Or you can go to immigrationforcouples.com and you can self-schedule 24/7. And actually, I'll go ahead and I'm going to throw that here in the comments for all of you. And I'd be happy to speak with you in private so you can schedule a consultation. We can meet on Zoom or on the phone and we can talk more and I can advise you on whether or not adjustment of status is a viable option or, what will be your best next steps to be able to petition for your wife. Okay? All right. So you received a 221G refusal. Why does the date update change? I'm not sure if I follow your question. So, yeah, I'm not sure if I'm understanding your question. So you'll get a refusal if you receive a 221G refusal at your interview. That's because either immigration says you're not eligible for the benefit, or you didn't present the required documents, or you could need a waiver. There's a lot of reasons why you'd get that 221G. In terms of the date changing, I'm not sure if you mean on like the US visa, like the status check. Sometimes that date will change because they have made some kind of update on your case. But yeah, again, I'm not clear if that's your question and if I'm answering it, but at least I can give you clarity on that 221G refusal. Oh, Lisa, about 2 more weeks for your son's fiance to arrive. That's awesome. I bet you're very happy. And you're welcome, Terry. My pleasure. And we're excited for you that you're so close to your interview. Please let us know how it goes. Sending you prayers and positive vibes from everybody here in the community. Okay. Hi to you as well. You're in Toronto. Your fiance got her, I think you mean her social security number, perhaps, within 1 month of entry. Yeah. Okay. So that's really common. After you receive the spouse visa approval, you enter the U.S. on that spouse visa. The Social Security cards arrive always, pretty much always before the green cards. The Social Security office, I guess, is a little faster than immigration. But yeah, usually our clients receive those in about 30 or so days, and then the green cards do take about 90 days, about 3 months. The spouse visa and the passport with the stamp is the temporary green card for a year. So immigration's not like in a huge rush to get you the card because they know you have that proof for a year. But yes, that's normal. That's very normal. Oh, Brenda, I think this is the missing piece of some of the missing pieces of the puzzle to your question that I was not following. So you were refused at the Nairobi embassy because you were missing some tax documents and you uploaded them the same day. Okay. So that yeah, that makes sense that you got them uploaded and it just will vary in terms of how long it takes immigration to review it and make a final decision. Yeah. Okay. So, how long will it take you to get an interview date? It's been 9 months since I was documentarily qualified or approved. Yeah, that's a popular question. How long will it take to get the interview? And it really depends. Um, I know nobody likes to hear it depends, especially when you're going through an immigration case. You just want some clarity. So it depends though on what is the U.S. embassy or consulate location. So for our clients that are going to go through a process in Nairobi, solid 18 months to receive an interview. I know that's insane. In Mexico, you're looking at like a year. We have had clients in London, though, for example, that get an interview within a month or so of being documentarily qualified. So it depends in large part on your case type. It depends on your embassy location, but hopefully you get an interview soon. Okay. Oh, and this you have a two-part a two-part question. So you said the attorney that you hired made a mistake on the consular application, and how can you correct it? So when you go to your interview, that's a good time to make that update because when you go to your interview, the immigration officer will be asking questions and reviewing that form as part of the interview. So just knowing, hey, these are the updates, these are the amendments, and letting the immigration officer know at the day of the interview, because once that DS 260 is submitted, there isn't a formal way to go in and amend it. So that's the best thing that you could do. Good morning, Ginger. It's good to see you. I wondered where you were. You're one of our regulars. I'm glad you were able to join us, even though it's on a Friday. Oh, and good morning. Good morning to you as well, Maria. It's great to have you with us. All right, let me see. Who is next? Okay, so your name's Kyle and your girlfriend lives in India. She would like to get her master's degree here. Do you know if fiance or spouse would be more beneficial for in-state tuition for Colorado? That's a really interesting question. I don't know if one would be more beneficial for in-state tuition because both options are going to lead to a green card status. So my consideration or the consideration I think that you would want to ask is, which visa, like what are some of your key priorities? Being together as soon as possible. I know that's everybody's priority. And that the second level of that is, does your fiance, future spouse need to be able to work and study immediately? Because fiance visas, clients choose those because you will be able to be together faster typically than the spouse visa. Whereas on the other hand, typically couples will choose the spouse visa because even though they know it takes much longer to be together, the individual gets to enter the United States with more mobility, more ability to work and travel internationally without so many limitations and restrictions. So it's those would be kind of the questions that you would want to work through. I really encourage you to check out the webinar that I had posted here earlier in the chat, the resource center. In that webinar, I talk about the options that are available to couples and the fiance and the spouse visa and considerations. But in terms of in-state tuition, I really think it's going to be pretty comparable because the end result is going to be a green card. And so you'd be wanting to look at that particular university and in-state tuition. Every state, the universities have those residency requirements in terms of how long you've lived there. But really, both options are going to lead to green card status. So you can kind of look at that with universities and see what does that look like for a tuition standpoint. All right. Yes, Lisa, I know you're saying the UGG so long for the wait times. Yes, indeed. All right. Oh, here. Yeah. And you said about 12 months residency before you can. Yeah. That sounds probably right. I know some are a year. Sometimes they can be 2 years. Who is next in the queue? My puppies are in here with me and they promised they were going to be quiet, but Charlie is breaking the rules. Somebody, a delivery driver, I think, is outside. And so he's grumbling about that. All right. So Ahmed, you're asking about the I-134 for the co-sponsor for the fiance visa. Is it that acceptable if your fiance does not meet the financial support requirement? Yes. So for any immigration case, fiance visas, any marriage-based green card case, part of that process is you have to show you as the petitioner, the U.S. citizen petitioner, that you have enough income to support your fiance or spouse. If you don't, then the next step is you have enough assets. And if you don't have enough assets, then the next step is having a joint sponsor. And yes, if you have a joint sponsor, forms have to be filled out for you as the petitioner and for the joint sponsor. Okay. Oh, 18 months to go for your wife and 15 months for my stepdaughter for the spouse visa. That's how long you've been waiting for the decisions. Is that what you're saying? Hopefully you get a decision soon. Sending you prayers and positive vibes. That's a long wait. I know. I really think I think it's really inhumane. And my team and I, we are always advocating for change. I have gone to Washington, D.C. I plan to go this year. The American Immigration Lawyers Association, we all go to Washington, D.C. There's thousands of us, and we are talking with members of of Congress, of the Senate, talking to them about the real life implications of these immigration wait times and the reform that needs to happen. And you can do that too. Like I had said earlier in the show, make your voice be heard. Education is huge. There's just so much out there about immigration that focuses a lot on the border and national security, and all of that, right, is important. And there's just so many nuances of immigration that people aren't aware of, like what spouses have to go through and how long the waits are. And educating others is something you can do. Educating your friends and family, letting them know what the immigration system is like when you are going through the process, trying to bring your spouse and children, and talking with your representatives, reaching out to your representatives and telling them your personal story and urging them to make change. That was my soapbox. I just had to do that. All right. Good. You're telling me it's helpful. Good. I'm glad. Good. Thank you. Getting the affirmations. Hey, Jose, it's great to see you. I was hoping that you were going to tell us your I-130 was approved, but I see you're still waiting. How does the priority date work? You filed the I-130 in March of 2024. So priority dates are going to be more applicable for categories that are not what they call immediate relatives. So if you're a U.S. citizen who's petitioning your spouse, minor children, and parents, you don't need to worry about the National Visa Center monthly bulletin and visa priority dates. Because there are other categories of immigrants who are called non-immediate relatives. So when you're a green card holder, a lawful permanent resident petitioning for your spouse or children, for example, not only do you have to wait the USCIS processing times, you have to wait for a visa to become available because there's only a limited amount of visas. So that's a long answer to say that unless you're in that permanent resident petitioning category, typically that priority date's not going to really have any bearing on your case. Okay, so you had a DNA test requested for a late registered birth certificate. Yep, that's pretty common. And what chances do you have of getting an approval? I would not be able to tell you that. I don't know all of the aspects and nuances and information of your case, but I will say we are all sending you prayers and positive vibes and hoping for a positive outcome for you and your family. Okay, so with a conditional green card, if I get divorced, what will happen? So a conditional green card, for those of you who are just starting out and aren't familiar with this term, when you go through a marriage green card process, you'll either receive a 2-year conditional card if you've been married for less than 2 years, or you'll receive a 10-year permanent card. If you receive a 2-year conditional card, you are expected to file an application with your spouse in the 90-day window right before your 2-year anniversary with proof of your relationship. If you are no longer in that relationship, if there was abuse, if there was divorce, and in really sad circumstances that, if there was a death, then you would have to take additional steps to ask immigration to approve your case, basically a waiver of that joint filing requirement, allowing you to file your case on your own. So, if you were to get divorced, it doesn't mean that you automatically lose your green card, but you will have additional steps and things that you need to prove to immigration. And I highly recommend in situations like that, definitely in situations like that, having an immigration attorney. And if you check out the free resource center on my website from that link that I provided earlier in the show, you should still see that in the comments. Go to that free resource center, and I have a whole section on the I-751 removal of conditions process, and I actually talk about this topic in even more detail. All right. All right, I have a couple more minutes that I can answer questions. I did want to check on my folks here on Instagram just because their questions don't come through. Okay, so someone on Instagram is saying that my husband and I are not living together and we don't have a joint bank account. He is on the car. We've submitted this with pictures, money transfers, and gifts. Is that a problem? So it depends on what your case type is. For an adjustment of status, that's a process that happens here in the US and you're living together, and immigration is going to expect your lives have been very commingled and combined. And if you're not living together, if you don't have joint finances, that can present a pretty big obstacle for you in the adjustment of status process. I think your earlier comment was that you are going through the spouse visa process. And so for couples who are living apart, immigration takes that into consideration. They do still want to see strong relationship evidence submitted, but when you're not living together, if it's not possible to join your finances, then you need to look at other categories of evidence and make sure you have enough evidence in those other categories, like proof of visits to see one another, proof of upcoming trips, proof of communication, maybe money transfers, gifts exchanged, and the list goes on. So hopefully that helps answer your question. Oh, and I realized I still had Belay's question up. You're very welcome, Joan. Thank you for the lovely comment. That makes me happy to know that this is helpful for all of you. I know there's just so much negativity out there in the world, and so I'm glad that I can create a safe place for all of you, so you know that you're not alone and have some support and guidance on this very important, complex journey. Oh, I love this question. So you're engaged, and your fiance has never been to America. Our wedding is in June. What visa should we file? So that's great. Congratulations. That's really exciting with your wedding being just right around the corner. I highly recommend that you schedule a call and we can talk in private, because I have a whole series of questions that I ask when I have a consultation with a couple to better understand your relationship, to better understand your goals. And then I can give you customized advice based on what personal information you share with me. And I can say, based on your goals, based on your background, based on immigration history, based on your relationship evidence, all the things you share with me, my strong advice is that you file X visa, be a fiance or spouse. And this is a perfect time to have that conversation before you get married. Because if you get married, then it's no longer a question of fiance and spouse visa because you're married. So you're no longer fiancés. And then you're really going to be pigeonholed into that spouse visa option once you're married. So if your plan is to get married and that's happening in June and you don't want to change that, then typically the option is going to be the spouse visa. So again, I would be happy to speak with you in private during a consultation. I can ask you all those questions. We can really do a deep dive into your personal situation, and I can give you my advice based on your goals. Also, you can check out that webinar that I created in the free resource center on our website, immigrationforcouples.com. And I talk about the different options that are available to couples, the pros and cons of the options, eligibility, and that would really give you a good idea as well. Aw, that's awesome. So, oops. So you said you downloaded you requested the copy of the book and you're in Fort Pierce, Florida driving. Great to have you with us. Okay. Yeah. What if the dependent child of an immigrant visa beneficiary through employment is about to age out? So if you mean an employment-based adjustment, that is outside my realm of joy genius expertise, if you will. I focus exclusively on the family law area of immigration, and I can give you general information that there is something called a Child Status Protective Act, CSPA. So when children are under 21, they're put in a different category, a different wait time. So when I was talking earlier about non-immigrant and immigrant visas, for children who are under 21, they don't have to be subject to annual visa allotments. Once children turn 21, though, they have a very much longer wait, often a decade wait or more, to be able to receive a green card if they're being petitioned by a parent. So there is this Child Status Protective Act. It's a really complex calculation that if the application was filed before age 21, the immigration uses it to determine whether or not that child is still, like, if they freeze their age before that age 21, so they can maintain the benefit of being in a much shorter line. So if so if you have an immigration attorney that's helping you navigate that process, that's something that they would work with you on to determine if the beneficiary child will be protected under the Child Status Protective Act. Yeah, good morning, and thank you very much for your comment. It is my pleasure. Having gone through an immigration journey with my husband, it was one of those puzzle pieces of life that really catapulted me into this work in the world, and so I love what I do. It's a pleasure to be with all of you. Oh, you're very welcome. I'm glad that that helps. Yes. Does USCIS offer fee waivers? Yes, in some cases, and you have to, of course, provide evidence of that, and it's not applicable for all case types. All right. I do need to jet. You're very welcome, Jose. Hopefully, you'll have an approval here in one of the next live events for us. Yeah, I love this question, Lisa. This is a good question. Does needing a waiver of any kind make you ineligible to adjust status? So, when you're going through a process to receive a green card with immigration, you have to be eligible, which means you can't have issues in your immigration history. Immigration has something called the Immigration and Nationality Act. It's a very long list of rules that has ineligibilities, issues that a person can have in their immigration history. So if you have overstayed your visa, if you worked in the United States without authorization, if you ever lied to immigration, so if you filed a tourist visa application and you weren't honest with your reasons in wanting to come to the US, there's so many issues that a person can have. And so if a person has one of those issues, I, as an immigration attorney, what I do is say, okay, these are the issues you have, And is there a way to overcome those issues through a waiver of forgiveness? In some cases, there are. In some cases, there's a way to ask for forgiveness through a waiver. And in other cases, a violation in the past might make you permanently ineligible. So, what happens is when an individual goes to their immigration interview, we know that they are going to be denied, and then we are going to have the opportunity to file a waiver. In some cases, we're able to file the waiver at the same time. But yes, the answer to your question is yes, if you have an issue, it does make you ineligible, but not it might not be permanently ineligible. There might be a way to overcome it. So you might get a denial at first, and we know that this denial is coming. Then we file a waiver. We ask for forgiveness. It's a very complex process. I've helped hundreds of couples get through it successfully, though. And you get the approval of your waiver, and then they can approve your green card. You've gotten forgiveness for that ineligibility. So hopefully that helps answer your question. That's a good one. And you learned so much. Good. I love nerding out on immigration, and I love that there's people who enjoy doing that with me. So awesome. All right. You're very welcome. It's great to be with all of you here today. I think we actually got through all of the questions. I am hopeful I did not miss any. And you're very welcome to everyone. I see I had some other comments here on Instagram. So it was great to be with all of you. Have a fantastic weekend. And please check out that free resource center. Please take care of yourselves. Limit the amount of social media and news that you're consuming. There's a lot more positivity in the world than all that negativity that's being thrown at us. So just try to take care of yourselves and your mindset and each other. Have a fantastic weekend. I will see you all next week, Tuesday at 11 a.m. Eastern Time. All right. Take care, everyone. Bye.